ADR concepts explained, a movie-style scenario for SQE1/FLK1. The glass-walled offices of Specter and Florrick LLP, a top city law firm. The skyline of London looms outside. Inside, tension crackles as two powerful clients, Tech Titan Limited and Green Energy plc, are locked in a bitter contract dispute over a failed joint venture. Harvey Specter, lead partner, sharp and strategic. Alicia Florrick, ADR specialist, empathetic and persuasive. Mike Ross, trainee solicitor, eager and quick-thinking. The mediator, neutral third party, calm and impartial. The judge, presiding over the case, wise and authoritative. Scene 1, the neutral third party. Alicia, before we go to court, let's try mediation. We'll have a neutral third party, a mediator, who won't take sides but will help us find common ground. A neutral third party is an independent individual, like a mediator or arbitrator, who facilitates negotiations or makes decisions in a dispute without favoring either side. In Churchill v. Merthyr Tydfil County Borough Council, 2023, the Court of Appeal highlighted the importance of a neutral third party in facilitating resolution outside the courtroom. Scene 2, the settlement agreement. Mediator, after hours of negotiation, both parties have agreed on terms. Let's draft a settlement agreement. Harvey, once signed, this agreement is legally binding. If either side breaches it, the courts can enforce it. A settlement agreement is a legally binding contract in which parties agree to resolve their dispute, often reached through negotiation or mediation. In Halsey v. Milton Keynes General NHS Trust, 2004, the court reinforced the value of settlement agreements reached through ADR. Scene 3, binding decision versus non-binding recommendation. Mike, what if we can't agree in mediation? Alicia, then we could try arbitration, where the arbitrator makes a binding decision, like a judge, but private. Or, we could use early neutral evaluation, where an expert gives a non-binding recommendation to help us see the likely outcome. A binding decision, as in arbitration, means the outcome is final and enforceable, just like a court judgment. In Fiona Trust and Holding Corporation v. Privalov, 2007, the House of Lords upheld the enforceability of arbitration awards. A non-binding recommendation, as an early neutral evaluation or mediation, is advice or an assessment that parties can consider but are not obliged to accept. In Seals and Seals v. Williams, 2008, early neutral evaluation was used to encourage settlement without binding the parties. Scene 4, confidentiality. Mediator, everything discussed here stays confidential. Nothing said in this room can be used in court if mediation fails. Confidentiality is a cornerstone of ADR, especially mediation. It ensures that parties can negotiate freely, knowing that offers, admissions, or discussions cannot be disclosed or used against them in subsequent litigation. This encourages openness and creative problem-solving. Scene 5, voluntary participation. Green Energy CEO, we're only here because we want to resolve this quickly and privately. Mediator, that's right. Mediation is voluntary, you can walk away at any time, unless the court orders otherwise. Voluntary participation means parties choose to engage in ADR of their own free will. Traditionally, mediation and most ADR processes are voluntary, but recent case law has shifted this principle in some contexts. Scene 6, court-ordered ADR. Judge, in chambers, given the nature of this dispute, I am ordering both parties to attempt mediation before this case proceeds to trial. Harvey, aside, looks like the Churchill case changed the game. Courts can now order us to mediate, even if we're not keen. Court-ordered ADR refers to situations where the court requires parties to participate in an ADR process, such as mediation, before litigation continues. In Churchill v. Merthyr Tydfil County Borough Council, 2023, the Court of Appeal confirmed that courts can lawfully order parties to engage in ADR, marking a significant shift from the earlier Halsey decision. After a tense but productive mediation, both parties sign a settlement agreement. The mediator congratulates them, and the judge notes the court's time and resources have been saved.